Yes.
Am I allowed? I beg to mention item number 3 on behalf of the Tapak with the consent of others for the
What the consent? There is nothing. It has been adjourned again and again. What happened to Tapak?
due to medical problems he couldn't medical problems.
Affidavit not yet filed also.
Huh?
Affidavit is filed. No problem.
Mr.
B. Sibo.
B.C.Bo, learn counsel for the appellant submits that leading counsel Mr. T. Tapak has some is indisposed, therefore press for listing of the matter after
3 weeks. Lots.
3 weeks. Praise the Lord. List according.
Marvelous.
Lordship, I would like to mention item number 9, Your Lordship. Here we have to file affidavit, Your Lordship. On
Yeah.
behalf, yes, 9.
On the prayer of M.S. Arbasar, Learned State Council, for the respondents, further 3 weeks time is granted to file affidavit in opposition.
Lordship.
Your Honor, this matter will is fixed for 10
Huh?
September, this matter.
3 weeks. Let them file first. Your name, please.
C. Siram.
C. Siram, Learned Council, appearing on behalf of. Your name is not there. Jitalo,
Yes.
Learned Council for the petitioner is present.
Obliged.
May I, my Lordship? I beg to mention item number 17.
Hmm.
Today morning, my senior, who is the conducting counsel in this criminal appeal, was informed by the learned PP that she is unwell and she won't be able to make it today. So kindly, this matter may be adjourned and listed after 3 weeks.
On the prayer, Mr.
MUB.
MUB, Learned Council appearing. Your name is there.
Yes, Your Honor. My
Learned
Lordship.
Council for the appellant. This matter after 3 weeks.
Highly obliged.
May I please receive? I make mention item number 16. Can this matter be adjourned for today and listed after 3 weeks?
You are still working,
Yes, sir.
Chairman.
Yes, sir.
Food Safety
Yes, sir.
Commission.
Yes.
Okay. Why?
Senior counsel is out of station, Your Lord.
On the ground that Mr. R. Learned Senior Counsel by the petitioners has some personal difficulty, Mr. M.
Taso.
Taso, Learned Counsel appearing on his press for listing of the matter after 3 weeks. Praise the Lord. List after 3 weeks.
I'm mentioning item number 4 on behalf of Senior Counsel Mr. Tara. He's out of station, Your Lordship.
On the prayer, Mr.
Piran, Your Lordship.
Pironya, Learned Counsel. Your name is there,
No, Your Lordship.
appearing on behalf of
Mr. Tara, Your Lordship. Titi Tara.
Learned Senior Counsel for the respondent. Let this matter be listed after
2 weeks. 2
2
weeks,
weeks.
Your Lordship. Obliged, Your.
My Lordship, I beg to mention item number 5. I'm for the respondent, Your Honor.
Huh.
Now, due to some difficulties, the conducting counsel couldn't come here.
Your Lordship, I'm for the appellant, Your Lordship.
And the matter may be fixed on.
Mr. E. Menjolan, Counsel for the appellant is present. As prayed for by Mr.
El Koyo.
El Koyulan, Counsel appearing on behalf of Mr. T. Taba, Learned State Counsel. For that 3 weeks time is
May I, Lordship?
granted to file affidavit in opposition.
My
May I
Lordship,
please,
it may
Your
be
Lordship?
fixed on 25th of this month.
You are supposed to file affidavit.
Yes, sir.
Affidavit in
May I please, Your Lordship? Your Lordship is well aware. This is a writ appeal, Your Lordship. And I think there is no requirement for filing counter affidavit, Your Lordship.
Okay. That is it. On the prayer over. No affidavit.
My Lordship, 25th of this month. Your Honor. 25th of this month.
2 weeks.
No, Your Lordship, if possible, then 27 of this month.
2 weeks.
Kindly please, Your Lordship.
2 weeks.
Highly obliged.
My Lordship,
When is everybody?
File nahi.
my Lordship, item number 13. My Lordship. I'm for the appellant here.
Yes.
Kindly, it may be fixed on some another date. Here.
Why?
And the conducting counsel couldn't appear today. My Lordship.
On the prayer of Mr.
El
This is
Koyo.
IA,
Yes.
condonation of delay.
3 days. Your Honor. Condemnation 3 days.
Well, issue notice.
Can I take
Notice probably issued or what? Notice already issued.
Issue.
Lordship,
Hmm.
we are appearing for the
And then the,
Yes. What is the delay? 3 days.
3 days, 3 days.
We'll condemn it. We'll condemn the delay. You be there. You be there.
reference also not yet filed, not
Okay.
received.
Okay, but then appeal you can.
Appeal, of course, appeal can be.
No,
closed, but
the
then
condemnation can be.
condemnation delay can be confirmed. And of course, in appeal also, the court can be called.
Mm.
They have also tried for suspension. Suspension, double, but in appeal also.
No, today is only for condemnation of delay.
Okay, that can be taken up.
We'll condemn the delay. We'll allow the application. Be there.
Your Honor, on the last, my lordship, on the last occasion, service was directed, Your Honor. It was, I think it is
He is
completed.
appearing.
Yes.
He is
Kindly-
appearing for the respondent number 2.
My lordship, kindly,
Right.
it may be fixed after 3 weeks.
Sir, we want to grant the relief to you, which you are seeking.
Yes,
You don't want.
yeah, one it.
On the prayer of Mr. So-and-so, land council petitioner appearing on behalf of applicant, appearing on behalf of Mr. Titaba, land council applicant, list this matter after.
No, anyway.
3 weeks.
In this case also is not listed. Suspension, application also not listed, but in it is there.
I think first it has to be condemned.
Hmm.
3 weeks.
Yes. Deeply.
Mr.
yes, Your Honor, Lordship.
S. Hirang, land council for the petition. The respondent number 2 is present.
May I, Your Lordship? I beg to mention item number 18.
18.
Yes, Your Lord. Leading counsel is currently out of station. So this matter may be listed at
On
the
the prayer of Mr.
J. Yasung,
J. Yusung, land council appearing on behalf of
A. Tatak.
Mr. A. Tatak, land council for the applicant. List this matter after 3 weeks.
So what remains?
Item number 1.
Yes, instruction.
No, my lord, I am yet to receive any instructions, my lord.
How?
My lord, in fact, we have agreed to the realignment, my lord, and we have asked the consultancy firm, my lord, for preparing the DPR, my lord. But
That we have seen. That's why we want whether that has been done or not.
that will be considered, my lord. There is a escalation of price, my lord. The price that they are quoting is a little bit high, my lord. So that has to be negated, my lord. So we are yet to receive an instruction from the headquarters, my lord.
You file affidavit to that extent.
My lord.
How long we will grant you time to obtain instruction? It's like a mockery.
3 weeks time, then, my lord. In the meantime, I will file my affidavit, my lord.
The order of court has to be some sanctity.
My lord, my lord.
It is 4 time, isn't it?
Yes, my lord.
Are we wrong?
No, my lord. Absolutely right, my lord.
And Mr.
Yellow.
K. Lole, land counsel for the petitioner, and also her MS. Mr.
My Lord, I put the respondent number 1 only.
M. Kato, land DSGI, and MS. C, and also her, Mr. M. Kato so and so, as well as so and so. K. Wangmo, land state council. Next para. Despite repeated opportunities granted to the respondent number
2, my lord.
respondent number NHIDCL
My lord.
to obtain instruction, no instruction is forthcoming. Mr. Please, how about Mr. Opada Land Council, Standing Council, Standing Council,
My lord.
NHIDCL submits that the authorities have agreed to have a realignment of the road, realignment of the construction of road is agreed by the prayed by the petitioner, petitioners, list of petitioner. But due to certain involvement of expenditures,
my lord.
The issue could not be finalized. List of considered above. Let this matter be listed after 2 weeks. In the meantime, Mr. Opa, the State Council to file to bring on record the submissions. To bring on record the instruction as submitted by him, as submitted here in above. By an affidavit.
My lord. My lord, may I humbly pray, my lord, 3 weeks time, my lord. Obliged, my lord. Deeply obliged.
Item number 2.
My pleasure, my lord. My lord, this appeal has been prepared against the conviction order of dated 12/11/2025 in connection.
List after 3 weeks. Separate order, huh? Same order, but separate.
Item number 7.
7, 8, 9. 8, 9.
Item number 10.
My lordship, the service is completed and today the matter is fixed with IA. But for IA, I need another day because the conducting council is not present here. A
Yes,
fixed date may be given for an IA.
service is complete.
Yes, my lord.
Yes,
So what is to be done?
it was fixed with an IA. So
If the TCR, whether if it is received, no, if it is received, my lord, then preparation of paper book.
Heard MS
M. Jarang.
N.
M. Jarang.
M. Jarang, counsel for the appellant. Your name is there?
Yes.
You are there? As well as Mr. Learner's Edition PP.
Your lordship, a fixed date may be given.
Trial court record. Record is received. Registry is directed to prepare paper book. List the matter up.
My lord, this may be clarified. Expenses to be borne by the petitioner because it's not a jail appeal.
For which the expenses shall be borne by the appellant.
Yes, my lord. Let it be on, my lord, according, they want fixed date for, my lord, pressing the IA.
Okay, it is on 22 September.
22 September.
Not in 25th.
Yeah, my lord.
Yes, not
Yes,
in
my lord.
25th of this August. 25th of this August.
August or September?
September को fix कर लो. Okay, then 22 of September.
Entire matter is to be carded. The record.
See, we'll see if it cannot be taken up. Let the paper book prepared pass.
Then 22. Your lordship.
22 September. Okay.
Obliged, my lord.
Item number 11.
11. Chief, your notice has been answered.
What is to be done?
Chief, I filed one additional affidavit.
Saying what?
Bringing in report that the complainant, during the time of filing complaint, she was posted at Itanagana. Now, Lordship, now she has been transferred to Alo, DMO. So, Lordship, I'm praying for fresh steps at her present address.
It should supposed to be, my lord, IA for correction of the address, actually, my lord. Not an additional affidavit.
IA?
But they file as an additional, my lord. Now here they are stating that the address has been changed. So it should be the IA. And if once IA is allowed, my lord, it will be modified, the cost in the cost title, the address, and accordingly, my lord, they will be directed to take fresh steps.
IA. We'll say IA. This should be listed as IA.
Yes, my lord.
Not the additional.
Yes, yes, my lord.
In fact, it is IA. IA is for what?
No, it's suspension.
My lord, one is for suspension.
Where is that IA? That additional.
Additional, my lord, they have filed.
I filed those.
When?
Last week, Lordship, I don't know the exact date.
What did you file? Where it is? That additional affidavit?
Lordship, it was filed on 13th, Lordship.
13 August?
Yes, Lordship.
It is submitted by Mr.
K. Parang.
K.
Parang, Your Worship. Okay.
Parang, Land Council for the appellant that an application for correction of the address of the respondent number
2, Lordship.
2 has been filed.
It's not there.
However, same is not placed with the record. And we have the registry to verify. And if the affidavit is filed, let same be tagged with the criminal appeal. List when Monday, Tuesday. Next Tuesday.
Next Tuesday, yes.
Next Tuesday. List on.
Next Tuesday. Anyway. Verify. Obligement.
Item number 12.
Wait.
May I please, my lord?
Yes.
My lord, service upon respondent number 2 is still awaited, my lord. So we will take
Mr.
steps. M. Ratan, my lord.
M.
Ratan.
M. Ratan, Land Council for the petitioner. Appellant. And Miss M.S. K. Wang, Land State Council for the respondents. Award service report, state respondents, award service board in respect of private respondents. List after 4 weeks.
My lord, interim is there.
Order past alliance should continue.
My lordship, this may be listed after a week, my lordship.
Why?
No, we will take steps.
What's the difficulty?
There's the interim. Interim is there, my lordship. So
We will take steps, my lord, upon respondent number 2.
Huh?
It's, we have to take steps.
3 weeks.
3
2 weeks. Then 2 weeks.
3 weeks, ma'am. Deeply understand.
Item number 14.
I have filed the condonation application.
The POCSO matter, my lord. Notice to the victim.
And Mr.
S. Rang,
S. Rang, Council for the applicant. This is an application under Section 5 of Indian Limitation Act 1963, praying for condonation of delay of 1527 days in filing the connected criminal appeal against the judgment of conviction and order of sentence dated 10/02/2022, passed in POCSO case number 08 of 2021. Whereby the applicant has been convicted under what?
Section, my lord,
Where is that's it?
Section 6 of POCSO Act, read with 506.
Where is the sentence?
Sentence is in
The applicant is conviction and sentenced to where it is.
It's there in my lord, main petition page number.
It's here also.
Okay.
I also.
64.
Page number
sentenced to
64, man.
Undergo rigorous imprisonment of 20 years. Under Section 6 of POCSO Act, with the fine of rupees, with the fine of rupees 5,000 under Section 6 of POCSO Act, and 1 year simple imprisonment under Section 506 IPC, with a fine of rupees 2,000. You said with a fine of rupees 2,000 under Section 506 of IPC. With default stipulation. Issue notice returnable by 3 weeks. Land Council for the applicant to take steps for service of notice upon respondent number 2. Prodi.
Office of PP notification 17, man.
Terms of the notification.
17, man.
17 of.
My lord, dated, I don't recall, man.
You take that.
I will give the date, my lord.
Notification number 17 of so and so.
Yes. Yes, obliged, man.
Item number 15.
Please, Your Lordship.
Hmm.
Cancellation of recruitment, Your Lordship. Your Lordship had, if Your Lordship remembers, last time had heard the matter a little bit, and
Even a little bit, we don't remember.
I was seeking the issues of cancellation of recruitment. There was after the cancellation of recruitment, there was a new advertisement in which we had also applied. And Your Lordship was, since it was in 2022, Your Lordship wanted to know whether recruitment process has completed.
Yes.
So far as I'm concerned, I'm rejected due to overage. So it doesn't matter to me anymore. So far as they are concerned, they had made a submission that till now nothing has been done since 2022.
So what is the way out? So how you are aggrieved now?
Lordship, in the initially when I was selected, there was 2 posts of UDC, out of which I was one of the selected candidates. They had cancelled the recruitment process itself after about 3 years. No, 4 years, because the initial advertisement was in 2018. In 2022, they cancelled everything. Then thereafter, in that same year, by the end of 2022, advertisement was again floated. That advertisement was for only 1 post this time. But it is not shown from the records as to what happened to the other post. So even if I had applied, of course, but there was a miscommunication between me and my client. So therefore, that was not reflected in my writ petition that I had applied. But I had challenged that second advertisement also. Nevertheless, Lordship, when I see the records now, since I have been rejected for being overage, at the time of filing the writ petition itself, I was already overage. So it matters very little. Now, I would like to argue the case on merits.
No, when you were already rejected on being overaged, what merit?
No, that is the second advertisement, Lordship. I was already approved for selection in the first advertisement. We had gone through everything, the recruitment process. But the reason for cancellation, they are saying so many things which are not telling with the records. First, they say that the name of the institute itself, the change of nomenclature. The change of nomenclature of the
advertisement, you applied, but then your candidature has been rejected because you are overaged.
This I came to know now only, because for many years they just kept it pending like that. So when I inquired, they told me that she has been already
The challenge to the fresh advertisement is no longer there.
Yes, it's no longer there.
Now, that press tender is, press advertisement is for those posts. Of course, maybe 1 post or 2 posts.
1 post.
1 post.
Yes.
What remains?
Lordship, if my
you are not challenging the fresh advertisement, if you cannot challenge it.
Yes, my lord.
What remains?
My lord, if my, because till now, since 2022, even if they have floated the second advertisement, since 2022, they have not gone ahead with the recruitment process. If my writ petition was allowed.
Even after the second advertisement.
Yes.
It has not been completed.
No. And one very interesting thing is that there were 2 posts earlier, for which I was one of the selected candidates, of which they had cancelled the recruitment process itself after attaining almost the final lap. What
is the finding of the learned single judge?
Finding of the learned single judge, your lordship will find at page 34.
34.
Yes. Sorry, page 33 onwards. May I read, Lordship?
relevant.
Yes. Lordship, before reading this, I would like to apprise this court that the reason they had given for cancellation of the recruitment process was number one, change of nomenclature. Change of nomenclature, not of the post, of the institute itself. Of the institute. Then there is a reference to some communication between the respondent authorities, which according to the learned single judge was not proper. Basing on this, my writ petition was dismissed. May I read now, Lordship, page 33? I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. As can be seen, the grievance of the petitioner is that she appeared for the selection test held for 2 posts of UDC pursuant to the advertisement dated 8/3/2019. This is wrong, actually. It is 2018. And she was shortlisted as one of the selected candidate for the said post, which is eminent from the communication dated 24/3/2020, made by the respondent number 3 to the respondent number 4. However, instead of declaring the results and appointing her, the respondent authorities have cancelled the recruitment process due to administrative reasons. What exactly is the administrative reason has been further explained by the respondents in their counter affidavit, stating that the recruitment process had to be cancelled on the ground of change of nomenclature and mandate of the institute. Further, the same was also due to some procedural infirmity in the selection process. It is seen that the respondent number 3 on 24/3/2020 had sent emails had sent the details of the conduct of written exam / skill test for filling up of Group B, various Group B and Group C posts under the establishment of the respondent number 4, which included the marks and list of selected and wait listed candidates against the respective group to which they belong to. The said communication was said to have been made by email. It is also seen that the copy of the communication has been marked with Under Secretary to the Government of India. Ministry of Ayush, New Delhi, for information. The respondent number 4, through its director on 25/3/2020, wrote to the Under Secretary to the Government of India, Ministry of Ayush, requesting the approval for a recommendation of respondent number 3 to take further action for appointment of the selected and eligible candidates. However, the Under Secretary on 1/4/2021 wrote back that there was a proposal to change the mandate and nomenclature on the institute, which was under consideration by the government. Therefore, it was decided not to proceed with the process for direct recruitment at the moment. Insofar as the representation of the petitioner was concerned, the Ministry of Ayush instructed the respondent number to dispose of the same in terms of the ministry's letter dated 1/4/2021. The communication was made to this effect on 10/5/2022. When the matter was taken up for hearing on 18/8/2023, this court, upon finding a mention about a letter dated 4/3/2021, this is important, Lordship, 4/3/2021 of the respondent number 4 to the Ministry of Ayush in the communication dated 1/4/2021, asked the learned DSGI to produce the same. Accordingly, the learned DSGI produced the said letter. A perusal of the letter written by the respondent number 4 through its director to the Deputy Secretary of the Government of India, Ministry of Ayush, goes to show that it is regarding certain queries sought from the respondent number 4 by the ministry. The question raised as to why the result of written exam skill was opened by the institute without placing the same before the selection committee. The reply to the query is that the results of the selection process conducted by the respondent number 3 was sent to the respondent number 3 was sent by the respondent number 3 to the respondent number 4 via email. As the communication attachment were addressed to the respondent number 4 institute, the same was opened by the director. Therefore, it appears that the communication was sent by email. The same lost confidentiality, which was one reason among others which prompted the issuance of instruction not to proceed with the process of direct recruitment. The other reason is noticed on account of the proposal to change the mandate and nomenclature of the institute, which was being considered by the government in the Ministry of Ayush. Therefore, the question arises, the question which arises is that the petitioner, having come to learn that she was one of the shortlisted candidates for 2 posts of UDC, can claim her appointment on the strength of such selection. It is now settled principle of law that mere inclusion of a name of a candidate in the select list does not confer on such candidate any vested right to get the order of appointment. And this Shankar Sankarsan Das was invoked, Lordship. That the state has no legal duty to fill up vacancies just because there is a mention of a select list. So what rejection of the learned single judge saying that there was infirmity. Now, Lordship, why I'm mentioning this letter dated 4/3/2021. What happened is that this 4/3/2021 was sent to the respondent number 4, that is the director, via email. For some reason, they say that, why have you opened it? The director has said by this letter that it was addressed to me, therefore I opened it. It was as simple as that. Now they have said that this is a loss of confidentiality. And it is also mentioned that without placing the same before the selection committee, the select list had attained its finality. It's not as if that after that select list result, there was another committee to be formed. It is not like that. It is a final select list. It was only to be published. It was sent to the director. That is number one. Number two, your Lordship will find very interesting, page 125 and 131. Lordship may compare these two.
It's okay. We are, I mean, little.
Lordship,
everything is over when the matter is already, there was a fresh advertisement of the same post.
that same advertisement was also challenged at that point of time. Of course, that time I didn't know I was.
You remember, yeah, then you have applied and your candidature has been rejected. What can we do now at this stage?
Lordship, if my writ petition was allowed, that select list could have been given effect to, Lordship.
No, it is.
Lordship, before that, Lordship may see page.
Once it is
Lordship,
scanned,
what I'm urging upon this, Lordship, is your Lordship knows it is a settled law that in matters of cancellation of recruitment, just because a select list is published, even if the candidate has no right, it does not, however, mean that the reasons for the selection cannot be judicially reviewed.
No,
That
I'm
is,
not saying that we cannot.
and the reasons, Lordship, will see the reasons, Lordship. If I say today that the sky,
Let's say administrative reason, it was open, lost the confidentiality.
Lordship, Lordship, that it was addressed to the respondent number 4.
It was not question of publication also. Result was not published as such.
It was not published, but there was no question of any placing before selection committee. Yes, there was no question because the select list was final. It was only, Lordship.
When if it is published, when if you are selected, as you said,
yes,
law is that you don't have.
Yes. I'm for one moment, Lordship.
It's very difficult.
Lordship. Lordship may hear me for just 10 minutes. My thing is, Lordship, if I say today that the sky is red, Lordship knows that the sky is blue, would it not be an insult to the senses of your Lordship's eyes and intelligence? This is what I'm saying. This is exactly what I'm saying, Lordship.
Sometimes it's not always blue when you look at.
Today,
sunrise and it's a different color. It's not all.
What I'm saying is, the Lordship, when things are done in such an arbitrary manner, which I will show from the facts, Lordship. The email was addressed to respondent number 4. Who else will open the email? Is the respondent number 4. How can he be questioned that why have you opened the email? That is the whole thing, Lordship. Another thing is the change of nomenclature. Lordship, their primary reason which they have stated is the change of nomenclature. Now there is a contradiction between the authorities themselves as to who initiated what name, what was the reason for the cancellation. That is why I am harping on page 125 and 131 of this appeal petition, Lordship. Lordship, just kindly see this, Lordship, before coming to that conclusion, Lordship.
No.
This is their part of the affidavit.
At this point of time, circumstances as such.
Yes.
I don't think any relief can be granted to you.
Lordship may.
And if no relief can be granted,
yes,
unnecessary academic
Lordship, they have not
For
gone ahead.
academic,
The advertisement which they floated in 2022. In 2000, it's almost,
I'm saying.
yes, yes. With the second advertisement which they have floated in 2022, till now they have not done anything.
No, it cannot be. You are nobody now to say all this.
Lordship.
Your candidature has been rejected.
Yes, Lordship. But Lordship.
Just wait.
But Lordship.
Just wait.
Yes.
Yes.
Lordship,
First interview was rejected. First selection process was rejected. On what basis you said?
they have cancelled the recruitment process itself. Number one, saying that there was a change of nomenclature of the institute, which has nothing to do with the post. The post will be there or not there as per whatever is the thing. Number one, there was a contradiction in that statement also, which I'm trying to show. When the case was filed, they came up with an affidavit saying that the letter which I have mentioned, that was not in the affidavit, but it was noticed that some letter was mentioned. When the letter was brought before this honorable court, it was a letter addressed to the respondent number 4, that is the director, saying that why have you opened the email? Director replied, the email was addressed to me, therefore I open it. That is honorable, the learned single judge was of the opinion that confidentiality was lost. Therefore,
about what? This letter related.
Letter was about the select list.
Result.
Select list.
So they are questioning.
The Lordship.
The questioning.
Yes.
The
confidentiality.
So doubting the.
Yes.
Okay.
But my point is, it was not that after that select list there was further anything to be done. It was only for notification. Because interview, everything over, it was a select list. It was sent to the director via email. And there was a query that why have you opened it? Director said, I have opened it because it was addressed to me. It was as simple as that. Now the learned, honorable single bench took it otherwise, saying that confidentiality has been lost and that it should have been placed before a selection committee. There was no selection committee. The selection was already done. It was only to be published. There was a misunderstanding there. Those are the only two reasons, Lordship.
Can we just see once the cancellation order?
Cancellation order, Lordship. Cancellation order, Lordship will find at page 44. Third August 22. Several other posts were cancelled. Not just, mine is at serial number 3.
Others also for the same ground.
Yes.
What were the result of the others?
That, Lordship, I have no idea.
Anyone can know?
Yes.
No idea.
Here, there are no reasons except for saying that it is hereby cancelled due to administrative reasons. It was as vague as that. Lordship will see the last line, administrative reasons.
That can be. Everything cannot be written here.
Yes, of course.
Administrative reasons. It's an order on notice.
Yes, Lordship.
So
this was the cancellation.
fair enough. And it's not only your case.
It's not only my case, Lord,
How
of
many-
course. But your Lordship knows how difficult it is to go through a recruitment process. After going on to the grind.
It cannot be your fault. But
Yes.
the problem is at this distant point of time.
Yes.
When everything has been, so many things have been developed or had been had happened, including your seeking participation in the fresh advertisement, your rejection of candidature. I mean, this is something.
Lordship,
Only that's why we're worried, we're afraid. What sort of relief we could give, even if you agree, accept your
yes
petition.
Yes.
What relief? We cannot direct them once it is. Press advertisement issued.
Yes.
Conclusion or not concluding, bring it to logical. It's a different thing altogether. But they have initiated another subsequent selection process.
Yes.
And we cannot just because only one post has been advertised. Earlier there are 2 posts.
No, Lordship, I'm not on that, Lordship.
Consider on that post.
I'm not on that,
Has
Lordship.
gone.
My submission is, Lordship, not everything is lost, because even if there was a second advertisement that has not been acted upon till now, it is not too late even now, because if my writ petition was allowed, if this honorable court allows my appeal, then, Lordship, that cancellation can be quashed, Lordship, the first cancellation. Before that, Lordship may come to page 125. This is regarding the change of nomenclature. This is a letter written to the director.
$125.
Yes, this is a part of the affidavit filed by the respondent. Lordship will see the date, 1st April 2021. This is to the director at Pasigat. Subject is conduct of written examination, /skill test for filling up of various group B and C posts of NEIFM, Pasigat regarding. I am directed to refer to your letter dated 4/3/2021. That is the letter which the Honorable Single Judge was referring to. On the subject above, and to say that the matter has been examined in the ministry, a proposal to change the mandate and nomenclature of the institute is under consideration by the government. It has been decided not to proceed with the process of the direct recruitment at this stage. However, for existing employees, DPCs may be held. This is 1st of April 2021. Then Lordship may come to page 131. This is again to the director. 2nd August, I am directed to inform your email dated 25/7/2022 of subject above mentioned, and to state that the competent authority has approved your proposal for cancellation of the recruitment process initiated by NEIFM for recruitment of Group B and Group C posts, included the post of pharmacist assistant account due to reasons specified by you. That is the change of nomenclature and mandate due to some procedural infirmity in the case. Lordship has seen page 125. In page 125, to the same director, the Undersecretary to the Government of India says that a proposal has been made that we're going to change the nomenclature. So therefore, we are deciding not to proceed. Then in page 131, he says it is your proposal for cancellation of recruitment process. So it seems that I'm saying that the sky is red instead of blue, and your lordship has to see that, lordship. It is not, lordship, the court maybe cannot go behind the reasons. Court has its limitations. I am very much agreeable to that, lordship. But there is something here, and this is also compounded by the fact that one post has been lost in the way.
What is that? What is that something?
Lordship?
What is that something which, according to you?
One post.
No, when you say that there is something.
Yes.
What is that something? Tell us.
Lordship, if it is the proposal of the director to change the nomenclature.
You show that this cancellation is only to deprive you.
There may be something else which we are not aware of.
That's why I'm asking.
And I am saying this
something else.
That, lordship, we don't know, but either the director has proposed or has not proposed. It cannot be he has both proposed and then he has been directed. That cannot be. There cannot be two opposing things. It cannot be black and white. Page 125 says that we are going to change the nomenclature. Page 131 says that on your proposal we have approved. This is something which is there, lordship, which I cannot say.
Page 125 says that the proposal to change the mandated nomenclature is under consideration.
Yes.
And therefore, they have decided not to proceed with the process of direct recruitment.
Yes.
At this stage.
Yes.
And ultimately, as per the director, is maybe whatever the reason.
Yes.
Some infirmity in the selection process or whatever.
No, there is, lordship, there is no.
I said infirmity.
No, lordship. There is no infirmity in the selection process. Only thing is that the email was opened by the director. That is the only thing. Otherwise, select list was already there. It is not that something else was to be done after that. That is what I'm saying, lordship.
Where is the select list?
Lordship?
Where is the select list?
The select list, lordship, will find at page 120. (121) is my name. Based on page 120, sorry, page 120A, because this was not very clear, so 120A, lordship will see the second paragraph. Based on the marks obtained by the candidates in the written test, skill test, the marks and list selected and wait-listed candidates against the respective Group B and Group C posts is as under. Now, my name appears at page 121. Name of the selected candidate. The first one, lordship. This is for the post of UDC. As your lordship must have seen in page 120A, it was addressed to the director.
Who has sent this?
This is sent by Director NEAH. NEIAH.
What is this?
This is by Lordship, in Eastern Institute of Ayurvedic and Homeopathy, under Ministry of Ayush, Shillong. They were the ones who had undertaken the recruitment process. As your Lordship can see, it is the select list. It is not as if there was something to be done after this.
No,
It was only a communication.
no, communication regarding the based on marks option. Then the selection. I think there should be a selection committee. Or the authority to approve, consider and approve it, and then only the result will be published.
Yes, result was not published yet.
In that case, only that you have been, you can
Yes.
report that you are
Yes.
you were selected. I think not otherwise. Yes.
Just one citation of them. This was a case in which cancellation of typing test was done due to some complaints by unsuccessful candidates. Regarding this, the Honorable Supreme Court had said in para 14 and 15, it is evident from the above that while no candidate acquires an indefeasible right to a post merely because he has appeared in the examination or even found a place in the select list, yet the state does not enjoy an unqualified prerogative to refuse an appointment in an arbitrary fashion and to disregard the merit of the candidates as reflected by the merit list prepared at the end of the selection process. The validity of the state's decision not to make an appointment is thus a matter which is not beyond judicial review before a competent writ court. If any such decision is indeed found to be arbitrary, appropriate directions can be issued. Para 15, to the same effect is the decision of this court in UT of Chandigarh versus Dilbagh Singh, where again this court reiterated that while a candidate who finds a place in the select list may have no vested right to be appointed to any post in the absence of any specific rules entitling him to the same, he may still be aggrieved of his non-appointment if the authority concerned acts arbitrarily or in a malefied manner. That was also a case in which the selection process had been cancelled by the Chandigarh administration upon receipt of complaints about the unfair and injudicious manner in which the select list of the candidates for appointment as conductors in CTU was prepared by the selection board. An inquiry got conducted in the said complaint, proved the allegations made by the an inquiry got conducted into the state complaint, proved that the allegations made in the complaint to be true. It was in that backdrop that the action taken by the Chandigarh administration was held to be neither discriminatory nor unjustified in the same, was duly supported by valid reasons for cancelling what was described by this court to be a dubious selection. Then what is, in such a case, what is arbitrariness that has been, Lordship, stated in para 18, 19, 20, and 21. I would like to read para 21, Lordship. There is no precise statutory or other definition for the term arbitrary. In Sri Lanka Vidyarthi versus State of UP, this court explained that the true import of the expression arbitrariness is more visualized than precisely stated or defined, or whether or not an act is arbitrary would be determined on the facts and circumstances of a given case. The court observed, the meaning and true import of arbitrariness is more easily visualized than precisely stated or defined. The question whether an impugned act is arbitrary or not is ultimately to be answered on the facts and circumstances of a given case. An obvious test to apply is to see whether there is any discernible principle emerging from the impugned act, and if so, to satisfy the test of reasonableness. Where a mode is prescribed for doing an act and there is no impediment in following that procedure, performance of that act otherwise, and in a manner which does not disclose any discernible principle, which is reasonable, may itself attract the vice of arbitrariness. Every state action must be informed by reason, and it follows that an act uninformed by reason is arbitrary. The rule of law contemplates governance by laws and not by humor, whims, or caprices of the man to whom the governance is entrusted for the time being. It is right that be you ever so high, the laws are above you. This is what men in power must remember always. Then, Lordship, para 31. The last line of this para 31 is, in my humble submission, very important. So also, whether the competent authority ought to have conducted an inquiry into a verification of the allegations before passing an order of cancellation is a matter which would depend upon the facts and circumstances of each case. It may often depend upon the nature, source, and credibility of the matter placed before the authority. It may also depend upon whether such exercise is feasible, having regard to the nature of the controversy, the constraints of time, effort, and expenses. And expense. Lordship, here I'm putting emphasis upon, but what is essential is that the authority making the order is alive to the material on the basis of which it purports to take a decision. It cannot act mechanically or under an impulse. For a writ court, judicially reviewing such order cannot countenance the exercise of power vested in a public authority except after due and proper application of mind. Any other view would amount to condoning a fraud upon such power which the authority exercising the same holds in trust not only to be exercised for a legitimate purpose and along settled principles of administrative law.
How the authority justifies this cancellation?
Which one, my lord?
Cancellation.
Cancellation, my lord. My lord, cancellation was because of the my lord, leakage of the my lord, the answer sheet, my lord. It was held. Result.
Any inquiry conducted?
No, nothing. Result was examination was held at.
Who decided this? That
My
there was
lord,
a leakage?
examination was held at Shillong. It was made correspondence to the department, and before that it was leakaged. So thereafter,
Is there any report?
no report there.
Okay.
So it was only mere communications between the conducting agency to the institution at Pasigat. And in the meantime, Your Honor, my lord, what happened? Then the cancellation was done. And in the meantime, mandate was changed, even nomenclature was changed. So therefore, the entire process has been cancelled. That was the whole reason. It is also,
all,
my lord,
all
reflected
this cancelled examination were conducted at the same time.
same time. Everything was on same date, same time. And of course, the post was different. Entire, my lord, the advertisement was cancelled and the press advertisement was issued, my lord.
Where do we find that communication where it was stated or informed that there was a leakage?
But therefore, there is administrative reason.
Okay.
That has not been given. Entire thing is not given, ma'am.
Okay.
That was the informative administrative reason. Nomenclature as well as the other. But exactly what was happened in this case? Before publication, this was open, and now they are releasing that respondent number 4, who is the director of the institute, has opened the seal envelope cover. And that way, the other candidates, they got to know the proposed final select list. Before finalization of everything, it was open, it was made circulated. Of course, that was one of the ground, but the sole ground, basic ground was regarding change of nomenclature and the mandate also. So in the meantime, that was cancelled. Now, Lordship, that had it been the case that if it is published after approval, it has to be finally approved by the screening board authorities, and thereafter it will be published in the newspaper. Even that was not taken place. It was just communication between the one institute to another institute just for finalization. Nothing was done. So therefore, my lord,
How do you hear that there was a leakage?
there was a
Any documents you show that in your affidavit?
my lord, that category was admittedly
Why
not
do you say
mentioned.
that there was a leakage?
Leakage means
It's a new concept or
no,
new
no, my lord.
grounds you are brought in.
That infirmities, they go before publication. They came to know about all this.
But Lal Single Judge has recorded that since the director has opened the
Yes.
the, the
Mail.
addressed to him,
Yes, that was the before
it
publication.
lost the confidence.
Confidential.
That's all.
That is the
What's the question of leakage?
leakage is something
Leakage
that
is very serious thing.
no, my lord. Leakage is in that
Leakage of the what leakage?
leakage. That means before publications of the entire shortlist that was open to the public candidate.
And that's why I'm saying anything to show that.
My lord, that is the only the contentions.
Even a statement, any statement in the affidavit to that extent.
To that extent, my lord, the affidavit filed by the respondent number 3. Due to procedural infirmities, that is specific.
What is that procedural infirmity?
For procedural infirmities, my lord, the conducting agency has to send the selected candidate, proposed selected candidate to the institute, and that will be approved by the ministry.
Has it been stated in your affidavit?
Yes, my lord. At page number, my lord, only procedural infirmities.
No, that's what is that procedural infirmity?
Infirmities, my lord.
It's a vague and very, broad term.
My lord, page number 107, man.
107.
Before publication, my lord, the made known to the candidates is also
Yes, where it is.
page number, my lord, 107. Para, it starts from para Roman, small Roman 3. Last line, page number 107. My lord, may I read, my lord? The Ministry of Ayush Government of India, by letter number dated so and so, so annexure 9, the approved cancellations of the process, recruitment process, the initiated by the so and so authority for recruitment to various group B and C post, including the post of the pharmacist so and so, on the ground of change of nomenclature and the mandate of the institute, and due to some procedural infirmities in the recruitment process. That was the whole reason, madam.
That's what I'm saying. What is that procedural
Procedural,
infirmity? What had happened?
My respectful submission, as I have already pointed out.
Suppose there was a leakage.
No, my lord. There was a leakage, not exactly leakage. It was just made known to the other before publication. It has to be, it's at least confidential.
How the public came to know?
My lord, candidate, that's why they are, they file their affidavit. They are time and again saying that no, we have been selected before publication, my lord. It is not supposed to known by the candidate before the, my lord, the final publication and approved by that. That was the one confidential, my lord.
Your submission has been stated anyway. That the before publication it was made known to the candidates and all.
My lord, that is the infirmities, my lord. Particular language, my lord, to that extent.
And what is the procedure?
Procedure, my lord, after examination conduct, it has to be sent to the scrutiny, marking everything. It has to be sent to the institute. The institute will again the constituted board will approve, and that authority will.
Under which rule? Any rule?
Malad, this is the recruitment process, Malad. Of
That's
course,
why
Malad.
recruitment process is based on certain principles and rules. I mean, instead.
Then after Malad, the ministry, Malad, this comes under the ministry. Ministry has to give approval, Malad. That final declarations has to be done by the ministry.
Sir, we understood, but we understand, but what we would like to know
Malad,
is
to
what
that
is the
extent, Malad, the
procedure?
guidelines regarding Malad, the conduct of the Malad, the recruitment process. Malad, that will be in the separate Malad, the recruitment process, Malad, the SOP, Malad.
You show us that. See, when you say the procedural infirmity, as you have submitted that after the conduct of the interview exams and all, it has to be sent to the institute, and institute have a selection committee or something like that, and it will be scrutinized.
Malad, in that case, Malad, other is also Malad, this is the another Malad.
No, that other submission will come.
Malad.
We'll just finish this first.
Malad, this is the Malad, exact Malad.
Can you show that you have been given time to file the affidavit? What is this procedural infirmity?
Malad, in fact, that to that extent, Malad, it was not before issue before the Malad, also Malad before the Lanet's honorable single bench, Malad.
You mean to say that the
No, this was the issue. You said that we have to cancel it.
What I'm submitting
Therefore, you said there was a procedural infirmity, and due to change of the nomenclature and the mandate of the institute, you have to cancel. Nomenclature, I don't know whether it's, we're not sure it can be a good ground for cancellation. That is something which we will not go into.
Yes,
but when you're taking the procedural infirmity, what constitutes a procedural infirmity
in that case, Malad,
is a process.
Malad, in that case,
and what you have submitted orally has been brought on record. Any statement in the affidavit? This is we just wanted to know.
Malad, in that case, Malad, may I pray that Malad, some more time may be granted, Malad. I'll come with that Malad SOP how to conduct the interview, Malad. It is not only with the Malad.
Error means you mean to say that this conducting agency could not have select or prepare the select list.
Select list, Malad, the examination, as I have pointed out, examination was conducted. Accordingly, Malad, the even marking was given. Even the proposed list was sent to the Malad, the institute. In the institute, Malad, the respondent number 4 is the
Is UDC or LDC?
UDC. UDC.
They, Malad, are open before publication, Malad, before approval, Malad.
The institution has same administration, I think. Change of nomenclature, how it affects.
Earlier, Malad, it was only
unless the ownership or the change of entire institution owned by or taken over by some other authority. How the change of nomenclature will affect.
True, Malad. That is the conducting, Malad, the recruitment process is something
That
different,
cannot be the
Malad.
good
Admittedly, to that extent, Malad, we also agree, Malad, that will not, Malad, otherwise change the circumstances, Malad, for recruitment process. However, Malad, decision was taken by the ministry to cancel the entire recruitment process. Malad, that is the policy decision maybe of the Malad.
What is the ground?
Malad.
Yes, with a good ground.
Lordship has already seen in the cancellation, Malad, Lordship has already seen that cancellation, Malad, that what they are submitting is, Malad, only mandate, Malad, the change of the nomenclature and the mandate, Malad. That is the whole reason, Malad. Here, Malad. And apart from that, Malad, the procedural infirmities which I have
It
pointed
is
out.
not a change of ownership.
Ownership, Malad, admittedly, Malad.
Then,
It is Malad, same ministry, same department.
then
But recruitment was conducted by the earlier, Malad, it was at Shillong, Malad. After conducting the Malad, the interview, Malad, the recruitment process, it was again sent to the Malad, the institute.
post backend is supposed to be remain the same even after the change of nomenclature also.
Sure.
The
post will maybe, Malad, the post will remain the same. However, Malad, only
Only at para 7. You've said
Yes, ma'am.
it was sent to ministry and ministry.
It is respectfully submitted that before this honorable court that the selection committee for the post of so and so has not been constituted, my lord. That is the another one.
Is
per the
LDC are concerned about UDC.
Yeah, ma'am. Has not been constituted, my lord. My lord, I hope, my lord, this will be the same process, my lord. There has not been constituted as per the recruitment so and so, and the list of the select candidates have not been prepared by this selection committee, my lord. That is the procedural infirmities, my lord. Only the marked list of the candidates who appeared in the examinations conducted by the Northeast the Institute of Ayurveda and Homeopathy, Shillong, have been sent to this institute by so and so Shillong, by email so and so at so and so so and so.
What's the requirement of selection committee after the
recruitment
process?
Committee, my lord, the committee has to examine. My lord, the committee has to, my lord, the the business of the committee
any
cannot be,
guideline, any rules.
the business of that selection committee cannot be, at this stage, there is no other instruction to that extent, However, the decision has been taken by the ministry to cancel this is one of the another the aspects that when it is cancelled, it was not published, The decision cited by my friend is of the publication of the select list,
No. The decision is it should not be arbitrary. Just because you have a power to cancel.
Once it is published,
authority to cancel, it doesn't mean that you cannot cancel it arbitrary.
Once it is published, to that extent,
It has
we
to be
agree,
supported by reasons.
Yes, However, in my case, in this present case, this is short list was not at all published, It was the only mere communications,
No, it's not a public. Forget about that.
Malad.
She is not claiming that since it was published, I should be appointed. What she is claiming is that you could not have cancelled it without giving a reason. The reasons and the decisions. There's no reason as such, but the decision of to cancel is arbitrary.
To that extent,
as it doesn't support a reason for cancellation, for change of nomenclature and mandate.
In that matter,
and there being any materials who show that there was a procedural infirmity.
I admit,
will have to show
admittedly,
from the record that there was by saying you have to show that there in fact was a procedural infirmity.
In that case, this everything may not be reflected in the it has to be.
But we grant you to file an affidavit. We could have
that part, I have filed already, That was the internal communication by additional affidavit.
What is this the procedural infirmity?
Procedural as
What consists of procedural infirmity?
Before constitution of the committee, before publications of the it has been opened by the
that you have not said so. Anywhere you have not said.
Procedural infirmity.
In affidavit, have you said so? That before the selection of the before was placed before the selection committee, it was open and was made public to the candidate, including candidates.
Admittedly, that extent.
I have read that. You read.
Yes, to that extent, it is not reflected.
But since you have, can you? This is also difficult.
Who was it? Can you clarify? I think clarify this. This is the first procedure. No ground, no regions.
What do you say? Yes.
Yes, my lord. Lordship has already seen paragraph 13. There also, my lord, we have specifically mentioned these are the communication, my lord. So therefore, my lord, the institution has reserved the rights to, my lord, cancel and, my lord, modified. This is the, my lord, in the advertisement, it has been categorically mentioned.
Decisions. Reserving a right to cancel or modify or do anything
My lord.
doesn't mean you'll do it arbitrarily.
My lord. My lord, this
There should be a justified reason.
to my that's respectful submission, it is a policy decisions of the the ministry to cancel. This is a change of nomenclature.
Policy decision cannot, you cannot have an arbitrary policy.
Another is
The highest
change
level of the decision making authority in the state, also in the country. Even the cabinet cannot.
change of policy decision is also the decision of the policy decision of the ministry.
How do you got it? How do you connect that recruitment and the change of nomenclature?
My responsible submission is
What is the next advertisement? Was it a UDC or something else?
It is inclusion.
Various posts, including
Various
UDC,
madam.
but only one post.
No. When you say that nomenclature was one of the reason for cancellation, can you connect that? Why this has to be just because change of the nomenclature it has to be cancelled?
As per the as per the ministry, as per
After the nomenclature in the subsequent advertisement,
what
was the post? Is the post remain UDC or something else?
It remained the same.
Ayush UDC or something like that.
That post remained the same.
Then
now, Lordship,
you may have a point if there was a, procedural infirmity or leakage or whatever, but you have not brought anything on record except for
for this department and this institute.
See, in the order we could understand, as I have indicated while Learned Counsel was submitting, everything cannot be spelled out in the order.
Lordship, in the
notice
for the department.
But you should, when you have been given an opportunity to file an affidavit, why there was a procedural infirmity, you could have brought it out.
Well, to that extent, it was not a procedural infirmities. We have already taken the ground, but some correspondence, email correspondence that was to be filed by way of additional that we have already filed. That was not.
For example, there's an arbitrary action. What constitutes arbitrary action will have to show. One has to say or one has to show. Likewise, when there was a procedural infirmity, what had happened, what procedural infirmity had occurred, that you have to explain. That is that which you have not done.
But the basic ground for the cancellation as per this cancellation order is
basic is for nomenclature. Which
change of and the mandate.
We are not that convinced. That's just for
since he is claiming for the claiming as a matter of right, therefore
that will come later.
Yes,
what is the basis of the reason for cancellation? change of nomenclature, we are not that.
My lord, in the government policy, my lord, the institute naming is also a kind of policy decision where, my lord, the recruitment has to be done for that
We'll grant
particular.
you one more time. Next Tuesday. Can you bring in someone on documents? I mean, records.
My lord, earlier,
Any file noting what had happened, something kind of thing that we can see. If there is.
then my lord, that file noting will be difficult to obtain.
No, I'm not saying just, I'm just in the, I mean,
My lord,
indicating
then in that
one of
case,
the
my lord,
the instance.
2 weeks time may be granted, my lord. I'll try to, my lord, come with the.
No, next week we'll finish it. We will spend around.
Now, my lord, earlier it was Northeast Institute of Folk Medicine only, my lord. Now, this was the advertisement during the, my lord, the first advertisement. After the change of nomenclature, my lord, it bears, my lord, it affects the institution name as well as the, my lord, the other employees also, my lord. Now, this has been changed to the, my lord, Northeast Institute of Ayurveda and Folk Medicine Recharge, my lord.
We'll take it up, whatever is there.
Okay.
Next Tuesday.
Okay.
We'll keep it part hard next week. All right.
My lord.
Or we'll dispose it today.
Your Lordship may dispose it of.
Why not dispose of, my lord? Everything is on record, my lord. However, my lord, one time chance may be granted, my lord. I'll come with the, my lord, if there is any change of the.
You make your submission. Either you want one more chance.
One more chance, my lord.
Okay.
On next Tuesday, my lord.
We'll not say anything. We'll keep it part hard. Is not it?
Yes.
But then, with an understanding that this point we'd like to, if you have anything, because it's nothing on record.
Yes.
We could have disposed of no issue, but then, but we'll keep it part hard.
Madam, they printed on 26, madam.
Tuesday.
26 is a Wednesday.
Make it Tuesday. Hearing day.
25th.
Then in that case, madam, on 27, madam.
27 is just Thursday.
Lordship is the,
On 24 and 25, madam, I'll be a little difficult.
Okay, make it 27.
27, madam. I'll try to come with that if any, madam, the correspondence from the ministry, madam, that part.
Heard MS
and Duncan.
and Duncan, Learned Counsel for the appellant, as well as Mr. M. Kato, Learned D is for the respondent. Heard in part. List again on 27/08/2026 for further hearing. It's coming up.
Okay. Okay.
Yes, we'll just take out this.
Or just.
Item number 19.
19.
Otherwise, it's only one.
Item 19. If they are ready, we'll come back. If they're not ready,
Yes.
See, item 19 is ready. Who is that keeper in legal counsel, legal aid counsel? PP. Additional PP. Kindly inform the PP and this keeper in legal aid counsel. We'll come back after 5 minutes.
I think this is the only method. If there's no, then no point if they are not there. Or what?
They may be around.
Okay. Okay. If ready, will come.
Kindly inform. Is this keeper ime? Keeper ime, sorry. Keeper ime and the advocate, the public prosecutor, whoever.
Okay.
Your Lordship, I deeply apologize, Your Lordship. Lordship, in this matter, my learned counsel El Hage was there, Your Lordship, and we have not been informed that she's not coming today. I was thinking that she's present in the court, and therefore our absence, Your Lordship.
So, legal aid counsel, keeper ime.
She seems to be absent today, you know.
Non appears for the parties on call. Next para. It is submitted by MST in Learned additional PP that the matter has been entrusted to one of the were interested to MSL learners edition PP. List of. What to do?
Next day. John.
Let's list. Since none appears for the parties, there's no other option than to adjourn the matter. List of accordingly, let this matter be listed after 3 weeks. MST Unit Learner Additional PP is requested to inform the legal aid counsel and her colleague Learned Additional PP about the adjournment of the matter.
Your Lordship, if I may mention item number 16 on behalf of M. Taji, Your Lordship. He's out of station, Your Lordship.
What remains here? Where is Mr. Tagum?
I have obtained consent, Your Lordship. I have obtained consent.
Call him. It's for payment of salary.
Yes, Your Lordship.
You cannot afford to keep it like this. You call him, huh? We'll take up. Yes, next.
Your Lordship, I'd like to mention item number 10. Here, the matter has become infructuous as
Learned counsel for the petition submits that writ petition has become infructuous. Accordingly, writ petition flows as infructuous.
Infructuous as because he has been transferred to other place.
Okay.
And this is the order.
If you are saying, we agree. Without any reservation.
Yes. All right.
Yes, this item 16. Why unnecessary skipping pen?
My lord, it's a request from the petitioner side only.
Have you seen the file?
Yes, my lord.
Non-payment of salary.
No, my lord. This altogether different. If you enter the merit, my lord.
No, I'm not questioning.
He has never been engaged, my lord.
Huh?
He was never been engaged, my lord. We have brought on record affidavit, my lord.
Then we'll dismiss it. If you
there's no case at all.
Not engaged, how can you claim for
that? Is why, my lord, we have brought on record affidavit, and so only because of the difficulties expressed by the petitioner's counsel, my lord. That's why.
Monday, we'll take it up.
Well, I don't know their part.
Next week, Lordship.
Huh?
Next week, Lordship.
Nothing will change. When you have not appointed, if you have appointed, we'll direct you to pay.
My lord, that part. We have brought on record everything.
If you have not appointed, how can you claim for salary?
My lord. And that too, more than 10 years.
Huh?
Saying that more than 10 years, my lord.
He's no longer there.
No longer. He's not there at all. Saying that sometimes in the 10 years back, he was there. And for that, there's nothing, my lord.
Very strange. Monday.
Yes, Your Lordship. I'll inform the leading counsel.
Huh. May not be interested to pursue because he, after filing, has he filed the affidavit in reply?
Not yet, my lord.
They have sought for it or what?
My lord, that part, my lord.
Okay, heard, Mr.
P. Ronya, Your Lordship, on behalf of...
P. Ronya, Learned Counsel for the Learned Counsel appearing on Mr. N. Taji, Learned Counsel for the petitioner, praised for listing of the matter after praised for some time. On the ground that Mr. N. Taji has some personal difficulty today. Next para, Mr. T. Tagum, Learned Standing Counsel Health and Family Service is present, who submits that the petitioner was never been appointed in the department. Therefore, there is no question of claiming for salary. Next para. Considering that the matter, considering the issue to the issue which pertains to claim for payment of salary. Come on, let this matter be listed on Monday. Monday is what? 24. List of, as agreed to by parties, list. No, and list the matter, and as agreed to by parties, list this matter on 24.
Obliged, Your Lordship.
I beg to mention item number 5, my lord. My lord, I have an instruction to withdraw this matter, my lord, as infractions, my lord.
Mr. T. Tagumlan Council for the Police submits that he has an instruction to withdraw this. No, he submits the writ petition has become infraction.
My lord.
Mr. Accordingly, writ petition clause on having infraxes. As infraxes.
As not pressed, my lord. Deeply obliged.
May it please, my lord. I would like to mention item number 15. I appear for the respondent number 6 under the instruction of my senior counsel. And Your Lord, I respectfully pray for short adjournment.
Why?
As the leading counsel is out of station due to medical emergencies.
Yes, for the petition, who is for?
No objection, Your Honor.
Huh?
I have taken the consent of the.
It's 2016 matter. It's not been settled.
No, Your Lord. No.
Building has been constructed.
Yes, already it's been constructed.
You have not settled the matter.
No. No.
It has become infraction. So much the allotment is you fight and all. Civil court. We cannot. Who has been allotted rightly or wrongly, we cannot decide. This is basically the permission to construct the building.
Yes, Lord.
The petitioner agree. Who is for the petitioner?
Yes, Your Honor. I'm for the
Have you
petition.
gone through the brief?
No, Your Honor. I've been instructed that respondent will take adjourn, Your Honor.
You have the file.
Yes, Your Honor.
You have the file.
Yes, Your Honor.
Go through it. It's listed for hearing. 2016 matter. We'll take it up. You also be ready.
Kindly pass over this method.
When any difficulty will grant adjourn. Will allow the adjournment if we find there is any difficulty. Go through it. After 1 hour, we'll take it up.
Much worse.
You have the file.
Yes, sir.
Go through it. Both. But you have to establish your case. Your job is more onerous than him.
Yeah.
Your Lordship, I beg to mention item number 11. I am for the petitioner.
Matter has become in process.
I am for the petitioners, my lord.
Yes.
The leading counsel for the petitioner is.
See, this is listed for orders. We have few matters. We'll see. Be there.
May I please also, I like to mention item number 6. Kindly, this matter will be adjourned for today.
The entry order will be vacated.
No, Your Honor.
Okay, on the prayer of Mr. M. Taso, Learned Counsel, appearing on behalf of Mr. Arjun Saikya, Learned Senior Counsel for the bill, this dismissed after 3 weeks.
Yes, Your Honor.
Yes.
As well as item number 7 as well.
7, what happened?
It's just question.
No, it's okay. That is granted by us. But then what happened?
No,
there was a proposal to shift all these gumtis.
No, it has not been done yet, Your Honor.
Why they have not done? Okay, which was the state? Any instruction?
No, my lord.
Why you are keeping silent?
But my lord, still gumtis are not shifted, my lord. Still, my lord, gumtis are not shifted, my lord. It's.
Do you have the instruction?
Yeah, only my lord, verbally, my lord, no written, my lord.
Are you sure?
Yes, my lord.
Okay, on the prayer of MST, T. Wang Council for the London State Council, further 3 weeks' time is granted to file affidavit. No,
Just interim, my lord. Already.
MS Mr. M. Taso, London Council for the petitioner is present. Interim order pass alia shall continue.
Lordship, I beg to mention item number 14, Lordship. Lordship, we need some more time to file our affidavit. I'm preparing for respondent number 3.
Okay. No objection.
Lordship, as instructed, we have also taken a step, but it was unserved, so kindly permit us to take fresh steps as well.
Item 14.
Yes.
Okay. Ms.
Key lawyer, Lordship, appearing for Mr. A. Apang, senior counsel.
Learned counsel. Appearing on behalf of Mr. A. Apang, learned senior counsel and standing counsel for nearest press foreign is granted 2 weeks time to file affidavit.
Yes, Your Lordship.
File affidavit in opposition. What do you have said? What do you want?
Yes, Lordship, we need some time to file our affidavit. 3 weeks time, Your Lordship.
You are for?
Respondent number 3, Lordship, nearest.
She is also nearest.
She
No,
is for the
I'm for
petitioner.
the petitioner.
Lordship.
Okay. Then petitioner? Heard so and so, huh? Then your name, please.
Key lawyer, Lordship.
For this thing. Ulta. Speak. No press steps. You are for?
Your Lordship, I'm for the petitioner. Actually, we have taken fresh steps against respondent. We have already taken steps against respondent number 2, but it was unserved. So kindly permit us to take fresh steps
so,
again.
MS?
P. Wangmo.
T.
P. Wangmo.
Wangmo. P. Wangmo, learned counsel for the petitioner submits that she may be granted a week's time to take press steps for service of notice upon respondent number
2.
Praise the Lord. List the matter after 3 weeks. In the meantime, in the meantime, as prayed for by T lawyer, MST lawyer.
Key lawyer, Lordship.
K lawyer, sorry, learned counsel appearing on behalf of Mr. A. Apang, learned senior counsel, standing counsel Neris to file affidavit in opposition.
Yes, Your Lordship. Obliged, Your Lordship.
Item number 1.
My lord, the petitioner is challenging the suspension order dated 27/6/2026, wherein the petitioner was placed under suspension with retrospective effect from 15/4/2025. It is after 14 months. My lord, can you see the page number 48?
48.
Yes.
Yes.
The impugned order. But this order issued on 27 June 2026. May I read, madam? Whereas Sri Taha Tagro, primary teacher, GPS Marak Radari district, has been arrested in connection with the violence, and a case has been registered under section such and such. Whereas the undersigned, in exercise of the power conferred by Sub-Rule 1, the date of detention in case of detention in trial for period exceeding 48 hours of Rule 10 of the CCS Rule 1965, hereby place the Sri Tahata Group primary teachers under suspension with immediate with effect from 15/4/2025. It is further ordered that during the period of trial, this order shall remain in force, and headquarters of Sri Tahata Group primary teachers Mara should be at Kradari district. And
yes, what's wrong? What's wrong here?
My lord, this
there's no dispute that you've been arrested and were under you have spent 48 hours.
Yes, after that, my lord, I was arrested in 15 and 15
40 hours. Have you spent 48 hours?
Yes, my lord.
Matter ends there. Heard, Mr.
My lord, after that, I have been released on 24.
Doesn't matter.
After that, I have discharging my duty.
Doesn't matter. It's an operation of law.
But as for the mandatory
Yes,
rule,
why so late?
My lord, this is here, my lord, the suspension, in case of suspension, my lord, the arresting authority has to intimate when it is arrested. And in case it is because of some reason, if it's not intimated, at least it is the duty of the person concerned, that is the petitioner, to intimate the authority that he has been arrested. But he has not done, and subsequently, when through our own source, when come to know that he has been arrested, that's why this order has been issued, my lord. There's a provision, my lord. My lord, this from department, my lord, from own source, my lord, from reliable source. Yes, we came to know that he was arrested. Then we made a communication with the concerned police, the authority, and from there, after confirmation, the order was issued.
So it took more than a year.
Yes, yes, my lord, because it was not there in my lord, under CCS rule, my lord. It is there because as long as if it is not intimated, this
release
period
release has no consequences.
My lord, intimation is consequential, my lord. From date of intimation, if he was arrested and detained, then the next is date of, it's count from the date when released, and second is it should also be intimated from intimation that
nobody has intimated.
Yes, my lord.
Taking it from the date of release.
Yes, yes, my lord. And from date of intimation, it will be
that Mr. O. Modi, learned counsel for the petitioner. Challenge made in this writ petition is to the order of suspension dated 27/06/2026 passed by the Commissioner, Education Government of Arunachal Pradesh, whereby petitioner is placed on the suspension with effect from 15/04/2025 on the under Rule 10, the CCA Rules 1965, on the ground of the petitioner being detained for a period of exceeding for a period of 48 hours. No, arrested and detained, arrested and detained for a period of exceeding 48 hours in connection with the what case? In connection with the case number 08 of 2025 under section 109 within 1 bracket 118 to page 48. Issue notice returnable by 4 weeks. What is your contention?
my lord, here, my lord,
As Mr. Who is one?
1 and 4, Your Lordship.
As Miss MS P. Sangeeta Learned State Council and Mr. T. Thagum Learned Standing Council for Education Department. Enters appearance and accepts notice on behalf of all the respondents. No form in notice need be served. However, extra copies be shown. Yes, what is your submission?
my lord, here in the order, it reflects that it is further ordered that during the period of trial, this order shall remain in force and remain in force. My lord, in this case, even no charge has been filed, yet filed.
It is submitted by Mr. And it is a contention of the petitioner that the authority could not have placed the petitioner under suspension with retrospective effect, as there is no intimation that too the suspension period will be for an entire period of trial of the case number 8 of 2025 list of no charge sheet has been filed as on today against the petitioner in the aforesaid case. List of therefore the placing the suspension of the petitioner for an entire period of trial, for the entire period of trial of the aforesaid case would violate the provisions of the law, inasmuch as the petitioner cannot be placed under suspension for an indefinite period without there being proper review and the extension, proper review oblique extension with the reasons as required under the rule. That's all. This is the matter after
2 weeks,
only 3 weeks.
3 weeks, my lord. Deeply applied.
Here's a point.
My lord.
Not indefinite.
My lord.
Item number 2.
Had MS and London Council for the petitioners. By filing this writ petition, the petitioners have put to challenge the recommendation of DPC dated 31/10/2025, whereby the petitioners have been, whereby the service of the petitioners have been regularized or promoted with prospective effect without considering that the petitioner were allowed to promoted.
Yes, promoted wide order dated 14/8/2015
Promoted
against substantive vacancies.
promoted on officiating basis.
Yes,
On so and so
14/8/2015.
2025
2015.
on substantive vacancies. List of the petitioner seeks promotion and regulation with retrospective effect, i.e. from the date of their officiating promotion, as their on the ground that they were promoted though on officiating, but on clear
Existing
substantive vacancies. List of consequent to that, the petitioner also challenges the impugned seniority list.
Yes.
Where it is?
Lordship,
Tell that.
Yes.
Impugned seniority list dated
19/5/2026.
19/5/2026, whereby the petitioners have been placed below the
Private respondents
who have been appointed through direct recruitments. Who are the direct recruitee and born in the cadre before after the petitioner were promoted on officiating basis. Issue notice returnable by 4 weeks, as Mr. Aritsnabam.
1 and 2, madam. 1 and 2.
Rest are
private
That's the private respondents.
okay. As Mr. Aritsnabam London Additional Advocate General enters and accept notices on behalf of for respondent 1 and 2, no comment notice change. Petitioners to take this test first time.
Requisites.
Private respondent. Requisite go.
Yes. Item number 3.
Wait, please, your Lordship.
Yes. What is this?
Lordship, we have filed a writ petition. Herein we are challenging the impugned order, transfer order.
What
dated
transfer?
4 August.
Why?
Lordship,
It's a common transfer on that page for 23.
yes.
Then
Lordship, it is I will humbly mention the grounds directly, Lordship.
What?
First ground is that, Lordship, I have only served for 9 months and 55 days. This is against the guidelines which are provided by the Department of Personnel.
Yes.
Yeah, which says, Lordship.
So it has no enforceable right.
Yes.
It's a mere guideline.
Yes.
You cannot, you don't have an enforceable right that you should be allowed to continue for 2 years. Yes, then.
Yes, that is my.
That is the only ground.
No, that is.
The next ground.
Lordship, second ground is that the whole transfer had taken place under the political influence.
How?
Lordship, I have annexed the order that is there in.
No, how can, in that case, how can there be a 15 members, 16 members? There is a common transfer order.
No, Lordship.
Where is that note? Do you have that note?
Yes, Lordship, I have.
Where
the
is
note.
it?
Page number 37, Lordship. Annex D, Lordship. If I may read, Lordship.
JPC.
Yes.
Very powerful.
Yes, Lordship. Transfer of Srimati Monungurang, DAO, East Coming District. Enclosed file here with the application submitted by JPMs of East Coming District seeking for transfer and posting Srimati Monungurang, DAO, East Coming. It is apprised your good office that Agriculture Department is line department of Panchayat. However, the present DAO SEPA is not cooperating with the PRI members of the East Coming District, and moreover, she is unable to deliver her duty. As such, after a common consensus of entire Panchayat member of East Coming District, the Honorable Minister of Home, DIA, Government of Arunachal Pradesh, is requested to transfer Srimati Monungurang. Lordship, here, what I humbly submit is that, Lordship, there was the transfer has to be passed by the department, but under the influence, the Jilla Parishad, we do not know what is the exact relation, but however, they have made an influence.
Okay, heard, Mr.
Lordship, another grounds are also there, Lordship.
What is that? How many grounds?
3 grounds, one last, Lordship.
What is the last?
Lordship, now in the prayer we are seeking for interim, Lordship, because I'll try to convince Lordship, because the other officer had also not yet arrived. So it will not prejudice anything.
What is your third ground? Tell us.
Yes, Lordship, my third ground is that, Lordship, humanitarian ground, Lordship. I have mentioned from time to time.
That we cannot. Personally, this court feel for you.
Yes, Lordship.
But legally humanitarian ground, we cannot.
Yes, Lordship.
Come up with legal ground.
Yes, legal ground would be, Lordship, this is a serious violation. Otherwise, I'd like to place a citation. Lordship.
Okay, heard, Mister?
I think also.
Yes. Why on the instance of?
No, it is not. It is purely administrative exigency, my lord.
How?
I'll part and for their benefit only, my lord. This is in terms of settle, my lord. In terms of seniority, my lord, it is necessary, my lord. If
what?
Otherwise, this is for their convenience, my lord, to so for smooth functioning of themselves only, my lord.
Huh?
This.
What is this?
This is, my lord. If my this minute, my lord, can how this is the region, my lord. If I am allowed to read this minute, my lord. This minor meeting of the
final seniority list. What is this?
Final seniority. That I'll demonstrate after reading this minute, my lord.
Yes.
If my
meeting. Yes.
Held, the meeting of past internal placement committee was held in the office chamber of such and such under the chairman of such and such following person, my lord. At the very outset, the chairman welcomed the internal placement committee member and thanks them for attending.
You read the relevant one.
Issue was, my lord, the selection of one, my lord, suitable officer for the posting of director committee. This is in view of the current committee director transition back to post of the director of marketing to be vacant on 30th July 2026, and the subsequent placement of senior most joint director as a director committee. Second, my lord, formulation of strategy to extend the operational function of committee. Committee, my lord, is a agriculture management and extension training institute, my lord. It is sponsored by central government, my lord, under
state agriculture. S is what? S is for what?
State agriculture, Lordship, management and extension training institute. Lordship, this is an autonomous institute which provides a specialized training for all the workers and farmers.
Deliberation and views of the members.
Kindly view or this or my note this also, my lord. The point, my lord.
What is the resolution?
The purpose that the prevailing system of
retain the current placement system, placing senior most in the tourism.
And my lord,
ultimately, my lord, after serious deliberation, my lord, this my lord discussion is in the ultimate, my lord, resolution, my lord, we'll see, my lord, resolution was passed, my lord. By 7-9 majority, my lord, recommending senior most JD as a director committee, my lord. Retain the current placement posting of assistant, placing senior most joint director as a director committee and senior DA for deputy director, my lord. My lord, and senior DA for deputy director posting committee, my lord. This is this is for
in the current placement system of placing senior most joint director as director committee and senior DAs for deputy director post at committee.
my lord. There are no such rule, but there are conventions in, my lord, decade, my lord. This is convention, my lord. Ultimately, senior most the joint director will be placed as a director committee, my lord. And the senior DAO will be placed as deputy director, my lord. Now, my lord, kindly have a seniority list, my lord. Seniority list, my lord, let's see, my lord.
This is of
seniority list, my lord. I have at past page, my lord. 16, my lord, will start on 16, my lord. 16 is also this is also one of the senior most DAO, my lord. 17 is also one of senior DAO, my lord. 18 is also this is also a DTO, my lord. And my lord will see it here, her name, petitioner name, prime place at page number 19, my lord. He is fourth senior DAO, my lord. Now, accordingly, my lord, now my lord will kindly have page number 19 of the edit petition, my lord. 19, my lord. My lord has seen the seniority list, my lord. Now, 8, my lord will see 8, my lord. Serial number 8, page number 19. This DA also, my lord.
Deputy director.
Was also as a deputy, placed as deputy director, my lord. He is deputy director, my lord. Now, other senior Bigam Padu, my lord, we find serial number 11, my lord. He has also been placed at, we are serving as DA Alo, my lord. Now he has been placed as deputy director committee, my lord. Now, petitioner, my lord. Come, find place at serial number 19, my lord. Here, 12, my lord, he has been placed deputy director, my lord. This is not internal management, my lord. It should be, my lord. After this, my lord, they will be after deputy director, my lord, they will be posted agronomist, my lord. And agronomist thereafter join from the senior most agronomist, my lord, they will be posted joint director, my lord.
Yes, it's a common,
my lord, now.
Common transfer. Yes.
Lordship, I'll just take 2 minutes only.
What 2 minutes?
Lordship, in the same page number.
No, there's a committee for of the department. They had a meeting headed by the director.
Yes, Lordship.
To place, and they've taken results to place the senior most deputy director. I mean, DAs.
DA, my lord.
District agriculture officers as a deputy director of committee. So according to 3-4 of them, including you, have been placed. What's wrong?
But Lordship, that is there, I accept it, but the
If you
deputy
accept
director.
that, if you accept that, it's quite reasonable.
No, Lordship, but it's on the second man basis.
Huh?
Deputation, Lordship. This is a second man summit.
We don't know. What about the others?
Others, Lordship.
What prejudice will cause to you?
No, Lordship, I'm only challenging the serial number 12. That is mine.
That's what I'm saying. What prejudice will cause to you if you are placed at the deputy director committee? And this letter is of which?
Lordship, this committee is for a time being only.
No, letter may be there, but this is not acted upon, my lord. This is totally internet placement, my lord, for a larger smooth functioning of the department, my lord. Otherwise, my lord, just
Mr.
Lordship, if you see the tenure also, it's only been 9 months. There was a frequent Lordship, transfer of mine.
Mr.
S. Ingti, Lordship.
Huh?
S. Ingti.
S.
Ingti, E-N-G-T-I, Lordship.
Ingti, Learned Council for the Ingti,
Lordship. E-N-G-T-I, Lordship.
Learned Council for the petitioner. Challenge made in this writ petition is to the order dated 04/08/2026 issued by the Secretary within bracket Agriculture, Government of Arunachal Pradesh, whereby as many as 39 officers of the department have been transferred and posted in different places of posting with different places of posting, including the petitioner. As many as 39 officers, including the petitioner.
Lordship, even I have
To
mentioned it.
different places of posting in their respective with respective in their respective capacities. List of the petitioner is transferred. It's page 19, from what is this? District Agriculture Officer, SEPA, as Deputy Director, Samiti.
My lord.
At what? At where?
He said on some Pasigat, my lord. It is
It doesn't indicate.
Yes, madam, but it is Pasigat, my
Deputy
lord.
Director, Samiti. What is Samiti? State Agriculture?
State, my lord, Agriculture Management and Extension Training Institute, my lord.
Extension?
My lord.
Where do you get it? Where do you get it?
Okay, I have
Samiti?
Yes, I've gone through yesterday night.
Where do you get this full form, Samiti?
Samiti, my
It
lord.
was there in
It is
the
not mentioned yet, my lord. In brief, my lord, instruction I have, my lord. It is a State Agriculture Management and Extension Training Institute, my lord. Samiti, my lord.
Extension, Management and Extension.
Extension, my lord.
Training Institute, Pasigat. Next para. The petitioner challenges the impugn transfer order in respect of her on mainly on three, essentially on three grounds. I.e., that she has not completed normal tenure of 2 years.
2 years, my lord.
In terms of the circular dated 09, circular dated 02, 06, 1998. Which regulates the transfer and posting of the officers and staff in the state of Arunachal Pradesh under the state government, that the transfer order has been issued at the instance of the Jilla Parishad Chairperson, East Coming District, by note dated 07/07/2026, and on humanitarian and on humanitarian ground.
Yes, Lordship.
What humanitarian ground?
Lordship, my son is suffering from kidney disease.
On family.
Every 3 times have to do dialysis. Lordship.
Family and family hardships.
And Lordship, I am only
The hardship of medical problem. Family hardship having with medical problems. Huh? List of issue notice returnable by 3 weeks as Mr. L. Perme, Leonard Standing Council, Agriculture Department enters appearance accepts notice on behalf of
One and
the
two.
older 1 and 2.
1 and 2, my lord.
Is there 3 is there?
3, my lord.
Private response is there?
Yes, my lord.
1 and 2, no form and notice needed. However, extra copies research. Petition to take steps for service of notice upon respondent number 3 by register post with village usual process. Next para, hard on interim prayer. Next para, the petition, the transfer, the commissioner, what is the secretary or commissioner?
Secretary, my lord.
Impugn order, sorry, next para, impugn order reflects that impugn order of transparent posting issued by secretary within bracket agriculture clearly reflects that as many as 39 officers have been posted to different officers, including the petitioner, have been posted, transparent posted to various places of posting and capacities, which is a common and routine, appears to be common and routine transfer in the interest of, in the administrative exigencies. List of the list of the permission of, transfer of the petitioner appears to be from a resolution by the internal placement committee of the department, which was conducted on 31/07/2026, whereby internally it has been decided that senior district agriculture officer shall be placed as deputy director at disseminate list of the resolution, the minutes of the meeting, the copy of the list of it also reflects that please stop. Consequent due to not only the petitioner but another 2 senior-most district agriculture officer have been posted as deputy director, committee. List of list in view of above. Considering above, this court is of the preemptive view that the transparent posting of the common transparent posting of the petitioners, the transfer of the officers of the department, including petitioner, appears to be in the administrative, in the interest of, in the administrative exigencies. As such, there's no, this court is not inclined to inclined to pass, inclined to grant inclined to pass any interim order staying the impute transfer order that it's so and so, so and so. Huh? Accordingly, the petition, the prayer for interim is declined. However, the transfer and posting of the petitioner shall be subject to the outcome of the writ petition. I will learn counsel for the petitioner to file, learn counsel for respondents to file affidavit in office. The honor before the next date of this thing. You file it, bring on record.
Other my issue, my lord, the person, my lord, who is relieve him, he is not a party in this case, my lord.
You just before that, minutes of that, the Mr. on the perusal of the copy of the minutes of the meeting placed by Mr. L. Perman, London Standing Council, Agriculture. Then you write that as per the. Otherwise, like we have taken it ourselves. Yes, you take it back.
Item number 4.
Thank you.
This situation presents a slightly a peculiar situation.
Yes, I also couldn't comprehend.
But one oral instructions may be sought for. We'll fix it next week.
Will not
Otherwise-
say anything. Heard, Mr. Who is border is that? We'll just say, will not say anything. This is something not only peculiar, something very,
why I'm saying
very,
is,
very strange for me.
but
Strange to this court.
Eastern government can ask the deputy commissioner whether it is available, and in the meantime, the High Court, Dangan can ask the registry because.
No, if the records are not
available,
traceable, what is the procedure?
No, my lord,
cannot be.
Since yes, I can directly file a fresh appeal, but then since it has come from this honorable court, so one or else in my alternative prayer is that I may be
obtain obtain instruction. Will not say anything. We'll just say,
let there be a judicial direction that to obtain instructions, my lord.
No, we'll say that to obtain instructions.
Yes.
Will the pertinent counsel by the petitioners. This writ petition is filed with the following prayers, page 14 to all prayers. MS G at Learned Edison Senior Government Advocate and MS N Learned Counsel for respondent for are directed to are granted 3 weeks time to obtain instruction.
Look, 3 weeks is we can take
2 weeks. 2 weeks time to obtain it. Just think about it, but
let it be.
maintainability.
No, but otherwise, your lordship's direction will not be implemented, and not only me, the other party also.
That's why I said I could not comprehend myself yesterday. How the writ will lie. Understand the difficulties. It is difficulties there.
Your lordship has you can always mold the.
That's the reason I'm just asking for instruction. Think about, take instruction, think about, apply your mind.
Fixed date may be given, Malan. But otherwise,
anyway, if the senior is so insisting, fixed date after 2 weeks, it may be convenient for you also.
Yes, Malan.
So that you can be, you can alert yourself. After 2 weeks,
A date,
7.
7 September.
7 September.
7th is Monday, Lordship. The may not.
My lord, 2 weeks means
Let it be on 9.
9.
9, let it be on 10th, otherwise then.
10. It's instruction in only says that to apply your mind. What would be the solution?
But whether the records are available or not. If not, then my lord, your lordship will decide.
I'm just suggesting. Instruction includes apply your mind. What would be the solution?
Because I cannot be left with
Yes.
no options.
Okay.
Applies, lordship.
Yes. Okay.
Item number 8 and 9.
May Your Lordship, in this matter, Your Lordship, we are yet to receive our instruction.
Which one?
Item number.
Affidavit opposition has been filed.
Yes, in item number 8, lordship, they have filed their affidavit.
Yes, Your Lordship.
In
In item number 9.
lordship, on last occasion on 31/7, when matter was listed at motion stage, my lordship has given direction to the government advocate to obtain instruction whether the petitioner, by which order the petitioner has been reinstated, with a direction to report before the Group A officer, lordship. But the petitioner is the Group A officer, gazetted, lordship. Only that point instruction was sought.
So what is to be done? What's to be done today?
Your
Lordship, I have shown a prima facie case, lordship. This first writ petition also, lordship, I have been transferred.
No, first writ petition, you are seeking what? Say payment of salary or what?
Yes, 3 months salary, lordship. I have been posted in a place where there is no office, lordship. Thereafter, I have submitted repeated representation.
So what they are saying now?
They are saying that you have not joined in the state department. Even without office, you have to join, as per their what they mean to say, lordship. I have been posted in Tinsukia. That the official status has, I have enclosed the annexure in item number 9 also. Here I have challenged the both transfer order. Initial transfer order and then present transfer order also, posting order, lordship.
Your Lordship, in this regard, we have received one instruction for the department, Your Lordship, but still then we need some clarification, Your Lordship.
No, what if, now there's a subsequent, this transfer order is no longer there.
Yes, sir.
No, that transfer order is
no,
not
in item 8, what you want?
In item 8, I'm seeking for a direction for release of my 3 months salary, lordship. Which they didn't pay, released.
Whether you serve or not?
I have not, sir, because I have been transferred at Tinsukia, lordship.
It's all right. Once you have not served, how can you be paid?
Lordship, there is no office, no place where I can
Has to
serve.
be regularized. All those things has to be done. Anyway, then it cannot be disposed of.
Lordship, they have obtained the instruction, lordship.
Yes, we have received the instruction.
Saying what?
Here, they are saying that the petitioner, Your Lordship, executive engineer, Your Lordship, has not submitted any representation, Your Lordship, on grievance, nor made any request to the department seeking a change of his present place of posting in connection with or account on the departmental inquiry pending against him, Your Lordship. And saying that in Your Lordship, in this one, no request from the concerned officer seeking a change of the place of posting is presently pending consideration before the department. However, keeping in view the pendency of the disciplinary proceeding and in the interest of the ensuring the smooth and impartial conduct of the inquiry, the competent authority undertake to ensure that the said office is posted at a suitable place during the period of the inquiry as may be appropriate in the interest of administrative, Your Lordship. We have received this instruction, Your Lordship.
Yes, Lordship.
What happened to that?
These are under progress, process, Lordship.
That has been revoked.
Yes, suspension was already revoked. Now they are saying the departmental inquiry is going on against me. For that reason, I have been posted at, before the Group B officer. I have to report as per this instruction, Lordship. There is only one sanction post for executive engineer that is at Naharlagan.
Let the instruction come.
In that case, Lordship, in the meantime, then, Lordship, that transfer order, that posting order may be stayed. Otherwise, tomorrow same problem will come up, saying that you have not joined at Namsai. And again, they will help. They will not release my salary also, Lordship. Same condition in the item number 8, Lordship. It was the same thing.
See, you are complicating the issue unnecessary. Petitioner. You are government servant. You will have to work out somewhere. You will work somewhere else.
Lordship, but Lordship, here.
We'll see next week.
Yes, Sir, Lordship. Next week, Your Lordship.
Complete instruction.
Okay, Your Lordship.
Heard Mr. K. Land Counsel for the petitioner. The MSP Land Counsel for the Land State Council submits that she is yet to receive the instruction as directed by this court. Therefore, press for a week's time to place the same. And we above let this matter be listed after a week.
Lordship, fixed date on Thursday, Lordship. Friday, Lordship.
Friday. Okay, Friday.
Hmm.
28, no?
Yes.
Obliged, Sir, Lordship.
Deeply obliged.
Item number 11.
Your Lordship, I am praying for an adjournment and my item number is 11. I am for the petitioner, the leading counsel for the petitioner is out of the station. He went to his native village due to ongoing.
This has been listed today.
Sorry, ongoing.
This has been listed today.
Yes, Your Lordship.
What for this is listed? In the office notice of February. Spread for by Mr.
Yes, sir. Yes, Your Lordship.
Your name, please.
Gomi Karbak, Your Lordship.
On behalf of Mr.
On behalf of Senior Advocate A. Bhattacharya ji.
Land Council for the this matter after 3 weeks. You are for?
Yeah, I'm for appearing for respondent number 4.
Okay, so what do you want? You have filed the affidavit.
General will file next.
In the meantime, Land Council for the respondent to file affidavit in opposition. MSP Pangu Land State Council is present.
1 to 3, Your Lordship. Obliged, Your Lordship.
Item number 12.
Yes, Lordship, I'm appearing for the petitioner and half of advocate and Rama, Lordship.
Mr.
And Kuma.
N. Fuba.
Kuma.
Kuma.
Yes, Lordship.
KUMA.
Yes, Lordship.
N. Kuma. Land Council appearing on behalf of Mr. N. Rama is present. Ever service report in respect of respondent 2, 3, and 4.
1, after 1.
MSP Arbas Land State Council is present. Just after 3 weeks. 3 weeks.
3 weeks. Obliged, Lordship.
Item number 13.
May I,
Answer
Your Honor?
notice. Insufficient address for delivery. You take fresh step,
Your Honor. Yes.
Mr.
Your Honor, also the government government is also yet to file affidavit.
Mr.
Extra.
A Young Fo.
Extra copies.
A Young Fo.
A Young for Learned Counsel. Your name is there.
Your Honor,
Appearing on behalf of Mr.
yeah,
Arson,
Arson, Your
Learned Counsel for the petitioner. Is granted, a fresh foreign is granted a week's time to file affidavit, to take the fresh steps for service of notice about respondent file. List the matter after 3 weeks. In the meantime, MS K. Wang Motlan State Council to file affidavit in opposition.
Item number 15.
Your Lordship, this matter has been fixed for today, and I am kindly praying for adjournment.
No, I have given you you are for petitioner.
I am for the respondent.
Your Honor, I am for
private
the
respondent.
petitioner.
So argue the matter, we'll dispose of.
Your Honor, standing counsel is, Your Honor, out of station.
Who is
I am
standing counsel?
Arson for the petitioner. Your Honor, at this stage, I'm not able. It is not possible for me to
Have you
appear.
gone through the,
Yes, Your Honor, but it is.
at least tell me what is the facts of the matter. Since you have gone through.
Your Honor, the humble petitioner, this present writ petition is filed under Article 226 for setting aside and quashing of impugn office order NLG LB 25.
Okay, don't tell that. Don't say that. Number is not required.
Your Honor, it was issued by this order is issued by the extra assistant commissioner, Itanagar Capital Complex, Narlagan.
Saying what?
Saying, Your Honor, Srimati Togyajur, private respondent number 6, has been allowed to carry her illegal construction activity on the duly allotted plot of land measuring 140 square meter, which was lawfully owned and possessed by the petitioner, Your Honor.
Yes.
Your Honor, also the petitioner is further assailing the legality and validity of the subsequent impugn office order dated 12/4/2016 and 12/7/2016. That is, Your Honor, Annexer 16 to 18. Passed by the Deputy Commissioner, Capital Complex, Itanagar.
See, your allotment is your Srimat Takam Yame.
Your Honor, yes.
Takam Yame.
Yes.
You have been issued the land passbook on the basis of not approved by the Honorable Minister LM. Right. Whereas he or she, her case has been properly, she has been allotted by following the formalities and the procedure. It's the same land.
Same.
What's wrong here? How can you be issued the land passbook on the approval, merely on the approval of the minister? It has to be approved by the government.
Your Honor, last opportunity may be given, Your Honor, since counsel is out of session.
Better listed for hearing. Come the Mr.
A Young Fo.
A Young Fo,
On the behalf of Arson.
Not behalf of Mr. Arson.
Arson.
phrase that matter may be adjourned on the ground that leading counsel, Mr. Arsenal, has some personal difficulty today. Considering that the matter is pending since 2016, the adjournment sought for is reluctantly granted. Accordingly, this matter after 2 weeks.
Your Honor,
Next week, Your Lordship.
Can it be
Fixed
done
date may
next
be
week?
given.
Your fixed date may be given if possible.
After 2 weeks, as a last chance. As a last chance.
Your Honor.
Mr.
NY.
N.
By BHAI.
Bahi.
Yes, yes.
Counsel appearing on behalf of respondent number 4.
6.
6 and MS. No, in that case, MS Arbasar London State Council and Mr. M. Bahi, London Council for Responsibility.
Your Honor, NY. N.
N for New York.
Yes, Your Honor.
New Zealand.
N by N. New York. NY.
Got it. Okay.